rise if able. These are appeals in the matters of HMRC and AXA Sun Life PLC and AXA Sun Life PLC and others, and commissioners of Inland Revenue and another.
Yes, Mr. Bremner.
My Lord, I'm obliged. I appear for the claimants at AXA. My own friends, Mr. Hewitt, King's Counsel, Ms. Belgrano, Ms. Ruxandu, and Mr. Wilmot Smith. I represent the revenue.
Yes.
I hope the court has the core bundle, supplementary bundle, and bundle of authorities.
Yeah, we've got 4 bundles of authorities. And we have read the reading list.
I'm extremely grateful. You'd have seen that there are the skeletons on both sides for the 2 appeals.
Yes.
Laid out, not in the most logical order, for which I apologise, but they are all there. The skeletons on each side, tabs 18 to 22. And we've got the agreed hearing timetable, which I hope the court has also had.
Yes.
I was proposing simply to follow that rather than to tell you again what is set out in it.
Am I right in understanding that we will be supplied with a transcript?
Yes.
And is that going to come daily, so to speak?
I believe so, my lord, yes. So what I propose to do is to start with AXA's appeal. That's dealing in turn with what we've called preliminary issue A and preliminary issue B. They're referred to in different ways. You'll see little Roman 1, little Roman 2, but for this hearing we'll just stick
limitation
with A, B and C. Yeah. A limitation and B set off. And that is my job of work between now and about 2:45 today. And then issue C is Malone Friends' appeal. That's pleading, ouster, and the income tax set-off point. So on issues A and B, different rulings, similar questions that arise. I'll need to show you, in particular, the prudential test case, the rulings made in it, what was at issue, what rulings were made, the extent to which those rulings are binding in terms of CPR Rule 19-23, and of course the question of ordering otherwise, which was left open by the judge because he didn't need to get to that question in the light of the rulings that he made. I've set out the background to AXA IUK and GREA's claims in paragraphs 4 to 11 of my skeleton at tab 18. I wasn't going to take you through the detail of that again, unless there are any points you particularly wanted to hear from me on. The details are set out in the judge's judgment at paragraph 7 and following, 7 and 8, which is page 89 in the bundle. And what you've got are these two claimants, AXA IUK, first of all, claim issued 8th of April 2003, claims going back to the accounting period ending 31 December 1995, and that, as it happens, relates to dividends, including dividends received in the 1992 accounting period. That comes up when we come to the point on carried forward double taxation relief under issue C. Although that claim was issued in 2003, it was stayed for many, many years because of the GLO having been made. And so what one has is a defence from the revenue first filed in January 2022, amended in September 2022, that's at tab 10, and then a reply from AXA 30th of September 2022, that's at tab 11. Prior to that, various amendments to the claim form particulars of claim, and I'll be looking at those, and I'm sure my own friend will be looking at those under issue C, but nothing particularly turns on that for the moment. Those steps in terms of completing the pleadings, they were taken as part of the directions for the determination of the preliminary issues, which I think I'm right in saying actually goes back to orders that my Lady Justice Falk made some time ago. AXA IUK, so that's the sixth claimant, it's claiming corporation tax that's been overpaid. Normally in these GLO cross-border dividend cases, we're talking about tax charged under Schedule D, Case 5 of the Income and Corporation Taxes Act 1988. As it happens, because AXA IUK is a general insurer, the tax was levied under Schedule D, Case 1, not Case 5. It's common ground that nothing turns on that difference between Case 5 and Case 1 for present purposes. There is an explanation, really, as to why it doesn't matter from Mr. Justice Henderson in Prudential High Court. It's at paragraph 27, and that's in the authorities at page 831. So AXA IUK's claim, that is for so-called mainstream corporation tax in the jargon of these cases. It's tax under Schedule D, Case 1. AXA IUK does not have a claim for advance corporation tax. The relevant details for the GREA claim.
Sorry, just before you go on, as I understand it, the AXA claim also relates to so-called portfolio.
That's right.
Lens.
Yes.
And am I right in thinking that was also the case for Prudential, because portfolio dividends were dealt with under the CFC, CFC GLO rather than the FIR?
Prudential also involved portfolio dividends. Yes, that's right. There is a slightly more complicated explanation as to exactly which claims go into the CFC and dividend GLO and which claims go into the FII GLO, but I don't think I need to get into that.
So for present purposes, it's not material, but as it happened, the Prudential also covered portfolio
yes,
dividends.
that is right. Prudential was a portfolio dividends claim, that is to say holdings of under 10%. And
speaking for myself, this case is complicated enough as it is without introducing any unnecessary complication.
And I'm certainly going to try to avoid doing that if I possibly can. So that's what one needs to know about AXA IUK in terms of what it is claiming and when it claimed it. GREA, the details for its claim are set out in paragraph 8 of the judge's judgment, page 89 of the core bundle. So GREA, its claim was brought by it being added as a claimant, and that was on the 20th of July 2009. Its claim is for restitution of unduly levied advance corporation tax. GREA is an ACT claim. And its claims go back to the 14th of January 1997. GREA does not have any claim for mainstream corporation tax. So AXA IUK, it's brought earlier in time, that's the 8th of April 2003, as we'll see, that's the same date that Prudential issued its claim, and its mainstream corporation tax that it wants GREA 20th of July 2009, and that is advance corporation tax. But for both of these claims, what we're dealing with under issue A is whether it's open to the revenue to run a limitation defence. So although the claims are for different things and made at different times, that's the common issue, if you like, under A that goes to both of those claims.
Can you just say a word on what difference it makes?
Yes, I was going to do that next. So for the practical effect of this, for AXA IUK, that will affect whether corporation tax paid by AXA IUK for the 1995 accounting period is within time. It's only payments within that period in respect of which AXA needs to rely on the extended limitation period in section 32(1)(c). As we understand it, all other payments are within 6 years of issue. For GREA, it concerns a payment of surplus ACT made in 1997. And if Your Lordship wishes to know the tax that we think is affected,
well, I wasn't thinking of that so much, but those amounts would be affected if your clients have a 6-year limitation period from payment.
yes.
I didn't understand it to be disputed that in principle payments are made under a mistake.
I understand that's right, that the
So
revenue is
the
not
question
charged.
is, well, what is the date for which HMRC are contending which will make the difference?
Well,
Which I haven't understood yet. So I can't, I don't know at the moment what difference it makes.
and it may be my friend will have to help on that. I mean, at this stage, what I'm saying is the revenue doesn't even get to have the
Well,
conversation.
I understand
the
that, but
ruling's been
it's
made.
quite helpful to know whether it makes a difference.
Indeed.
Do you have a case as to when the date of reasonable discoverability would be?
Well, we would be saying, because what would happen if the judge's ruling on issue A is left undisturbed, there would then have to be a determination as to what the date is.
Yes, but do you have a case on it?
Yes, and we've pleaded that the mistake was discovered within 6 years of the date of issue, so that would be not earlier than 8 April 97 for AXA IUK and 20 July 2003 for GREA.
Curiously, in your Frankovich claim, you say it was all obvious in 1986.
Well, there are different tests. We went through quite a lot of this in front of Mr. Justice Richards in November last year in FII, and what one can draw out of what's said about matters for Frankovich and the like. But that's the answer to the question as to what the case on what the dates would be is. So if the judge's ruling is left undisturbed, there would have to be a determination of that question. The determination of that question presumably would be informed by the ruling that has been made in FII, because that's looking much more closely at the state of knowledge and what the date is in a closely related context, but it would need a determination in this case.
Yeah, that was another reason why I wanted to know what difference it makes in regard to what Mr. Justice Richards decided in the VAT case.
Well, were that ruling to be applied, and it's not a given that the revenue would accept that it is to be applied, but the dates that Mr. Justice Richards has identified, which is the date of the Fakoyan judgment in, I think, June 2000, if memory serves, on that finding, these claims would be in time anyway.
Quite.
But of course, there is an appeal to this court to be heard in May next year on that question.
So the BAT case is under appeal?
Yes, it is.
Am I right in thinking the onus is on the claimant to identify the date?
The claimant bears the burden of establishing that section 32(1)(c) applies, yes. So it has to show that it could not, before a date that's within time, have discovered to the requisite standard. So can I just make a couple of submissions in overview as to why we say that it's not open to the revenue to run this limitation defence, and why we don't even get to the further questions that might arise if that defence is available. I say that the revenue's limitation defence was rejected in the prudential test case, and that ruling is binding under Rule 23. We've got a judgment and an order on the GLO issue of limitation, and there is no basis for making an otherwise order. The two key points are these. First of all, the revenue accepted in prudential that the date of constructive discovery was at the earliest the date of the Court of Justice's judgment on the first reference in FII. That was the 12th of December 2006. And that was why this court refused the Revenue permission to advance an earlier date, and the earlier date the Revenue was relying on was the 8th of March 2001. That, as it happens, was the date of the Court of Justice's ruling in Hurst. The court refused the Revenue permission to argue even for that date in Prudential Court of Appeal, and I'll show the court the passages. And I'll also show the court, in particular, the Revenue skeleton before this court in Prudential, which makes that clear, and I'll show you what was said to Mr. Justice Henderson, which is also fully consistent with that. And the result of that, I say, is that there has been a ruling, the effect of which is that claims brought within 6 years of 12 December 2006 are within time, and that's binding under 19-23. Now, the second point is if there's some doubt about that, or if I'm wrong about that, there shouldn't be, and in my submission I'm not, but if there is, then what we do have when one looks at Prudential are binding rulings that the date for claims to recover overpaid corporation tax, it cannot be before the 14th of July 1998. And I'll show you it's paragraph 255 in Prudential High Court that makes that good. That's good enough for AXA IUK and its corporation tax claims. And the date for claims to recover overpaid ACT, that cannot be before the 19th of October 2003. And if I need to go that far, that would also get GREA home. So if I cut to the chase on this, and I will need to show you how this unfolded, but the easiest way of doing it is to begin actually where the limitation issue is finally determined in the Prudential test case. And that's with this court's ruling on limitation. And that is at Authorities tab 30. Starting at page 913, and I'm very sorry because what I don't have is anything that relates my tabs to what's in your lordship's files. And I'll see what I can do to. I'm very grateful. And so the discussion of the limitation issue, that is beginning at paragraph 156, which is page 951. Now, the context of this was that the Revenue had sought permission to appeal against Mr. Justice Henderson's ruling that the ACT claims were in time, and permission to appeal was refused. And all I really need is within paragraph 158. And one can see letter G to H should have been common ground that if section 320 was invalid, then Prudential would have been entitled to rely on section 32(1)(c). And then as the court notes just above H, the Revenue wished to appeal on the question whether the judge was right in what he decided, and also wished to argue that Prudential could, with reasonable diligence, have discovered the mistake earlier than it did. And just pausing there, I said that the date for which the Revenue wanted to argue before this court was the 8th of March 2001. You'll see that in the Revenue skeleton argument for that hearing, and that's in the supplementary bundle. It's tab 30. It starts at page 255 as the front page. What we've got is an extract. The limitation submissions start at paragraph 84 on page 256. But it's at 258, paragraph 92, that you'll see the 8th of March date, which is what the Revenue want to put in issue in Prudential Court of Appeal. That's the date of Hurst. And going back to paragraph 90 at the bottom of page 257, the Revenue makes clear its own position It says that before the learned judge, the defence had assumed, and the learned judge came to a probable view, that in the event that Section 320 is invalid, the issue was academic, since the claimants would be able to rely on 32(1)(c) read short, and that's on the ground they could not have been aware of the invalidity of the ACT provisions before, at the earliest, the decision in FIECJ1 in December 2006. That's where I'm getting the 12th of December 2006 date from. That's the date of the Court of Justice's ruling on the first reference. And that reflects how the Revenue had put its case before Mr. Justice Henderson. This is the observation we make at paragraph 35 in our skeleton. It's under reference to paragraph 42 in the judge's judgment, where you'll have seen
Sorry, where's a reference to 42?
Oh, I'm so sorry. The judge's judgment, paragraph 42, is in...
Mr. Justice Richards.
This is Mr. Justice Richards.
Yeah.
It's in the core bundle at page 98. That's when Milano Friends submitted to Mr. Justice Henderson that all of this is only relevant, and by all of this he meant the points about relating back, which were the points on limitation that were actually being argued. All of this is only relevant if Section 320 is valid. If it's not, then it doesn't matter. These points are academic. And we've got that passage in the original, also in the supplementary bundle. It's at page 246. In the supplementary bundle, the beginning of the limitations submissions. And I'm not going to take the court through what was actually argued. You'll see the points on relating back are set out, 246 and 247, but it's internal page 47, so it's the right-hand column of page 247. A third of the way down, it's lines 17 to 22. That's the passage that the judge is quoting in paragraph 42 of his judgment. So what's happened is the Revenue running out its argument on same or similar facts in terms of Section 35, but then saying their position is, well, all of this is only relevant if Section 320 is valid. Of course, we know that Section 320 was not valid. So we have in my submission a ruling on the GLO issue of limitation. The claims in the test case, they're held to be in time.
Sorry, the ruling is what? That the claims were in time?
The ruling I say is that the earliest date for the purposes of Section 32(1)(c) is the 12th of December 2006.
Sorry, whose ruling is that?
I say that's the effect of this court's ruling on the basis of the Revenue's concession.
Paragraph 158 is the Court of Appeal's judgment.
Yes.
We refused permission to appeal because it was a new issue.
And it had been common ground before the judge.
What's the ruling?
The ruling is that the Revenue was not permitted to advance its limitation defence. It wasn't permitted to argue for 8th of March 2001. And that's on the basis of a concession that the earliest date is the 12th of December 2006. And so I say that the ruling is that the earliest date is the 12th of December 2006. It follows from the way in which the issue was decided. I also, as it happens, say that the ruling...
The ruling is in the refusal of permission to appeal. For HMRC to advance an earlier date than 2006.
Yep. I also say that I will get home. I need to do a slightly longer explanation of this, but I will get home on the basis of a ruling that the claims brought in the test case are in time. So I'm not, it's not 12th of December 2006 or bust. But if I'm wrong about 12th of December 2006, I need to explain in a little bit more detail how I get there. And the point is that...
So just to help me, apologies for going back to this, obviously that date of 2006 doesn't appear in the Court of Appeal's judgment.
No,
You
that's
get-
right.
It's not is it obvious from Mr. Justice Henderson's judgment.
It's pretty obvious from Mr. Justice Henderson's judgment, yes. But the Court of Appeal's ruling reflects the concession that was made by the Revenue. That's why I showed you paragraph 90 of the Revenue skeleton. So that's the basis of the refusal of permission. That's why I tie it in to the 12th of December 2006. And that's why I say it's helpful to start there, because you can see what was at issue, and you can see what the Revenue was and was not permitted to argue, and you can see why. Now, what I need to do, of course, is to put that ruling into context and look at what it was that was actually ordered in the test case, because the effect of this court's refusal of permission in Prudential is that the relevant aspects of Mr. Justice Henderson's order, they were undisturbed. There is, of course, a prior question as to what actually were the issues in Prudential. The judge, rightly in my submission, accepted that Prudential did determine limitation issues as GLO issues. That's paragraph 63 of his judgment. But where he then went wrong, and you see this particularly, for example, in paragraph 69, is in his analysis as to what the content of the GLO issue was. Now, my learned friend, in his respondent's notice, he challenges the conclusion that there were GLO issues at all. So that point arises really in response to my appeal. Given the debate about, well, what's the content of the rulings, it's probably most helpful if I simply show you what the issues were in Prudential, rather than sort of taking that as a given, because I'm going to have to do that anyway, in order to show you what it is that's been decided, and hopefully that should save some time if and when we get to reply on the question of was there a GLO issue. The judge, so Mr. Justice Richards, he set out the position in relation to the GLO and how it developed in paragraphs 19 through to 27 of his judgment. That's court page 93. And it's probably useful to have that summary on hand. I'm just going to very briefly show the court the most important material in the original. So that's how we get to the determination of limitation issues. So if I can start with the GLO itself, which is referred to by the judge at paragraph 19. That's in the supplementary bundle at tab 4, page 26. And that was first made 30th of July 2003. You can see from the very long heading, which goes into all the coloured writing of all the amendments. Paragraph 1 on page 27. It's applying to claims in respect to the following common or related issues of law. And then paragraph 1D, it's the compatibility of the case 1 and 5 charge on overseas dividend income with EU law. And then 1E is the GLO issue in relation to the compatibility of the ACT system. And then there's quite a long tail piece starting halfway down page 28. And one can see these are the issues of law arising for claims brought for declaratory relief, restitution and or damages. And it's on the basis that, and the relevant basis is what is set out in the last 4 sentences of that paragraph. So 4 lines from the bottom, it's and for the corporation tax treatment of dividends received from companies resident in other states beside the UK, etc. And it's those claims which you see from the final subparagraph within paragraph 1. Those claims are to constitute the CFC and dividend group litigation, bottom of page 28. And what's going to happen is that the common or related issues of law arising from these claims, they're to be particularised in accordance with paragraph 11 of the order. And I'll show the court what was done with that. Paragraph 2 identifies who the claimants are, and that's done by reference to Schedule 1. The schedule's blank in the version that was in the court. The judge had in front of him the group register. That's something like 245 pages long, so I hope it's helpful that we haven't burdened you with that as well. And the group register provision for that's made in paragraph 4. It's paragraph 11 that sets out a procedure. This is the bottom of page 30. The details of the procedure don't really matter, but that sets out a procedure for identifying the common issues of fact and law. You'll see from paragraph 11a that it involves input both from lead solicitors for the claimants and also the defendant solicitors, and the result of that we'll see in Schedule 3, which I'll show you in a moment. And I said AXA's claim was stayed. That was the result of paragraph 12, bottom of page 31. And then skipping on to page 34, that's the start of the schedules. And Schedule 1's blank in this version. Schedule 2 identifies various classes. And just in case it matters, we are dealing with Class 3, dividends received from EU resident companies. Class 6 on page 37, dividends from non-EU resident companies. And Class 7, which is ACT. Class 8 on page 38, that was added later, and that's the separate class of claimants dealt with by the Chancellor in the Class 8 proceedings. They're claimants with claim forms issued after 31st of March 2010. The salience of that is that's the 1 April 2010 is the date when the Para 51.6 ouster came in, and they're the claimants for whom on limitation Barclays was the test case. That was a claim issued in 2014. AXA's not in Class 8, and that's common ground. So what I really need from this order is what's set out in Schedule 3, which gives us the GLO issues. You can see at the top of page 39, they were the issues agreed by the parties and incorporated by the management court under the Para 11 procedure. And the way it's done is in a couple of sections. There are EU issues and then there are third country issues in section 2. And for both EU issues and third country issues, those issues included whether claims could be brought in restitution from the stake and also the applicable date for the commencement of the limitation period. And you see that for the EU issues as limitation A and B at the bottom of page 40. And that raises the question in terms, from what date does the applicable limitation period start to run? And in either event, and my submission is looking at either if it's a mistake of law, or alternatively, is it either damages or unlawful demand?
Yeah, and then we've got that repeated on page 42.
Repeated for the third country issues, that's exactly right. On 42, it's the same formulation.
Yeah, so that's how matters stood when Mr. Justice Henderson had his case management conference. And he directed the parties to agree the issues, which they did.
Yeah. And then Prudential is designated as the test case. I'll very quickly show you that because I need to deal with the links in the chain. Deal with Prudential as the test case and then deal with what was actually at issue at the trial. Prudential as the test case you get from the order, that was Mr. Justice Park, is it happens, tab 5 of the supplementary bundle, page 58. And it's paragraph 3.1 little b on page 59, which designates the prudential case as the test case for a series of issues, including EU issues limitation A and B and third country issues limitation A and B.
There haven't been other test cases in this flow.
No. And I was just, there's a side...
Leaving to one side Class 8.
It's Class 8 I'm treating as a sort of different thing. Prudential was the one and only test case for these issues. There was a possibility, and one can see it in 3.1 little d, that there might be additional test cases for factual aspects relevant to certain issues which are not represented by the substantive test case. That was... the substantive test case, of course, is prudential. No such test case was designated, so prudential is meant to be representative. Indeed, it is the only test case. And the reason I mentioned paragraph 27 in Mr. Justice Henderson's judgment, that was when he explains that prudential, it's a life assurer, it's dealing with case 5. Actually, its facts are thought to be more complicated. It's dealing with a broader range of issues, and so it should cover everybody. That was certainly the understanding of how this should play out.
And the test claimants don't seem to have paid any attention to paragraph 4.2 of the order.
Well, any reply, there was no reply served. That's right. It didn't require a reply, but you know.
Why did it not require a reply? Why did you not need to plead section 32(1)(c)?
Well, I don't. In my submission,
limitation is a defence. It's pleaded in the defence.
Indeed, it's pleaded.
If you want to say it's not 6 years from the cause of action, you say so in the reply.
Well, one would normally do that, but I have noted for the court a passage in Professor McGee's book on limitation periods, which does say it's not. It's no whether that's right or not.
It's an extraordinary point for him to make. To say.
Well, it's what he says, and whether
suppose you wanted to say that the defendant deliberately concealed a fact, you just turn up with some evidence at trial.
Well, I well recall that your lordship was in Prudential Court of Appeal, so knows these issues as well as my own friend and I were also there. It is a fact there was no reply in the Prudential test case. It is also a fact that limitation was live. The point was argued out without objection. Milano Friend was at pains to say, I'm not taking a pleading point. He didn't take a pleading point. The point was decided. And I fully accept there wasn't no reply. I also recognise that the court is perfectly entitled to and may disagree with what Professor McGee has said. But that doesn't alter the fact in my submission that there has been a determination of the issue of limitation. It was argued out and it was decided. I was simply making the point that what was required in the order in paragraph 4.2 was the filing of any reply. It did not mandate a reply. It may have been much more sensible if a reply had been served. No reply was served. I hope that clarifies what I'm saying. And then just for completeness, 3.4 and 3.5, still within this order, trials of the test claims to be heard together, and all issues, including liability for restitution, are to be heard together. That's paragraph 3.5. And then 5.1 deals with fixing the trial date, and that's the trial that's ultimately heard by Mr. Justice Henderson. And I'll go next, if I may please, to his judgment, which is Authorities tab 29, starting at page 817.
Sorry, where are we going?
So I'm in the
We're going to Prudential High Court, are we?
Prudential High Court, yes. Authorities tab 29.
paragraph, which paragraph?
Well, so
7.
So the most important paragraphs are at 248 and following. Just so you have the history, that's set out at paragraphs 1 and 2, page 825. I don't need any of that detail for present purposes. There had already been hearings in 2009 and 2010 of the trial, and they were adjourned, and the reasons are set out in paragraphs 4 and 5. And then on limitation, it is paragraphs 248 and following, which is page 908. And at paragraph 248, that sets out the issues agreed under the heading of limitation. So to what extent is the claim statute barred by a 6-year limitation period? And to what extent is the claim for recovery under a mistake of law barred by Section 320 Finance Act 2004? And the drafting of that issue, in my submission, it reflects the revenue's acceptance that if Section 320 is not valid, then the other points on limitation are, in Learned Friend's words, academic. So the only points being argued out by the revenue are the ones that are then dealt with in 249 and following by Mr. Justice Henderson. They're the only things that it was thought needed to be decided, because the revenue was accepting that if Section 320 was invalid, then the claims were within time, and I've explained the basis upon which that acceptance was made.
I understand that, but is that what the issue is confined to? Issue 2, under limitation, is a straightforward, is Section 320 valid or not?
Yes.
That's straightforward. But
and court
248(1) doesn't ask, is the claim statute barred by a 6-year limitation? It's asked to what extent.
Yes.
So if there were an issue about when the mistake was discoverable, that would be encompassed within issue 1.
Yes, that
So
would be
if
right.
you say, well, we couldn't have discovered it until, let's suppose, 1995, and the revenue say, yes, you could have discovered it in 1986, and therefore half your claim is
Yes.
statute barred.
Yes, no, that must be right. And what we'll see is that the answer on any sensible reading of the judgment and order is that the answer to the question, to what extent is the claim statute barred, is not at all. That's where we get to, precisely because the claim in the test case is held to be in time, and in time to its full extent.
Or is the answer, I don't know, is the answer to 2481, it's not barred by a 6-year limitation period, because that all depends on the extent to which Section 32(1)(c applies.
Well, let me show your lordship the judgment and then critically the order, because the order in particular will make good my submission that all of the claim is in time. So one needs to look at these issues in the light of the prudential procedural history that's set out in paragraph 249 by Mr. Justice Henderson. We've summarised it at paragraph 19 of our skeleton. Can I try and boil it down as much as I can? You've got Prudential's claim first issued on 8 April 2003, and that's, I'll call them PAC, that was Prudential Assurance Company. And that was a corporation tax claim, and it covered periods beyond the usual 6-year time limit. There's an issue about claims being added for third countries that I don't particularly need to worry about at the moment. What is more significant is 14th of July 04, which is noted in 249 little c. That's the addition of Prudential Holborn Life, which is referred to as PHL in the judgment. And at that stage, PHL's claims, they were of a similar nature to those of PAC. What happened after that, 24th of November 2004, there were some amendments to add additional claims. And then importantly, and this is little I, 19th of October 2009, that's the addition of claims in respect of ACT. What you had was both PAC and PHL making claims in respect of payments of tax that had been made more than 6 years before the date of issue of the claim form. And so to succeed in respect of those payments of tax, both PAC and PHL, they need Section 32(1)(c) of the Limitation Act. And Your Lordship, as already you have well in mind the point on pleadings, limitations in the revenue's defence, there is no reply. There was evidence from Prudential at trial, as it happens, from Mr. McCulloch. That was unchallenged evidence about when he was able to reach a view that there might be unlawfulness. What happened was that only this very limited argument was advanced by the revenue in relation to limitation. Now, the reason for that, if one stands back and thinks about how the law stood as at 2013, and my submission is obvious, at the time of the Prudential trial, the law was as set out by the House of Lords in Deutsche Morgen Grenfell in its decision in 2006, October 2006. And that, of course, ruled that the discoverability of the mistake, it depended upon the true state of affairs being there to be discovered. And that, for example, is Lord Hoffman at paragraph 31, Lord Hope at 71. I wasn't going to sort of rake over old ground with all of that, but that was the state of the law as it stood in 2013, before it was overruled in Supreme Court 2. And that's why the basis of the revenue's limitation argument in Prudential was Section 320. That provision, it's set out in paragraph 250 in Mr. Justice Henderson's judgment, and that turns off in subsection 1 the extended limitation period for claims relating to a taxation matter. And as it happens in sub 6, it does so regardless of how the claim is expressed, so whether it's mistake of law, unlawful demand. Presumably the reason for that is that at that time in 2004, it was thought still to be up for debate as to the extent to which a Woolwich claim might benefit from Section 32(1)(c). We know, of course, as the law turned out, that mistake has to be an essential element of the cause of action. That was FI Supreme Court 1, I think, among other places. But you can see what the draftsman has done in sub 6. He's saying, I don't care how you've brought this claim, we're turning off the extended period for a tax matter. So, in relation to PAC and PHL, looking at that procedural history in 249, PAC, it had brought its claim before Section 320 came into force. PHL had brought claim after Section 320 came into force. The ACT claims had been added for both in 2009, and of course 320 was in force at that time. So 320 potentially applicable to all of PHL's claims, potentially applicable to PAC's claims made after 8th September 2003, and that's what one sees in paragraph 254 in Mr. Justice Henderson's judgment. Now, of course, we know 320 is challenged as being incompatible with EU law. Ultimately, it's held to be invalid. At the time of the Prudential trial, FII Supreme Court 1 had happened, and Your Lordship will recall there was a split decision on Section 320. So Section 107 of FA 07, everyone agreed that was invalid. A split on 320, and that is one of the issues that goes on the third reference. And at the time of the Prudential HC judgment, the CJU has not yet given its judgment on the third reference. That is given in December, I think, 13, after the judgment, but before the order in January 2014. That's the reason why Mr. Justice Henderson's expressing himself in the terms that he is. And so paragraph 252, he sets out towards the bottom of 909 the two questions that were argued before him. And that's dealing first with PHL's claims and secondly with the ACT claims. And then 253 is the point about 320 being under challenge. And what Mr. Justice Henderson does is he then considers those questions on two bases, which he introduces in the last sentence of 253. First of all, on the basis that the section is assumed to be valid, and that's the assumption he's applying in 254. And he reaches various conclusions. And then in 255, he does it on the basis that the section is invalid. Now, in this case, before Mr. Justice Richards, my friend had a submission that Mr. Justice Henderson had got this the wrong way round. This is in paragraph 54 in Mr. Justice Richards' judgment. And that was a submission intended to suggest that, well, one could sort of draw even less out of this judgment because it had somehow been decided on the wrong basis. The judge thought that there was something in the point, but he thought it didn't contribute very much to understanding the judgment. That's paragraph 55 of the judgment below. I say, just to put a marker down, that finding's wrong. Mr. Justice Henderson, he was exactly right in the way that he saw the significance of section 320 feeding through if it was valid and if it was invalid. The reason for that, just in case this becomes important, comes out of section 320 sub 2, which is set out at the top of page 909 by Mr. Justice Henderson. Because if the section is valid, what it does is it turns off relating back.
Sorry, wait a minute. Where do you say it was set out?
It's set out at the top of page 909.
909?
Yes.
Yeah, sorry. Yes.
It's section 320 sub 2. What that's doing is modifying section 35(5)(a), and essentially it's turning off relating back for claims made on or after the 20th of November 2003. And that would have covered all of PHL's claims and it would have covered the ACT claims. And so I do say that that observation that the judge made in 55, that was wrong. The basis upon which Mr. Justice Henderson approached these issues, that was right. So his assessment of the position, paragraph 254, looks at the matter on the basis the section was valid. He said, well, that's got no effect on PAC's original claim or on amendments on 2nd of September 03. But then all the subsequent amendments, they would be confined to a 6-year limitation period. That, of course, ultimately is irrelevant because we know the section is invalid, and that's the question that's turned to in paragraph 255.
That does slightly suggest that when he refers to a 6-year limitation period, that means without extension under section 32(1)(c).
Yes. I think that must be right. Because it's the effect. This is looking at 254, my lord.
Yes.
Yes. Yes. I think because the premise of this is that 320 is valid, and so one is simply looking really at, are we looking at a claim or amendment made after the relevant commencement date, and there are different commencement dates in different parts of 320.
Yeah.
But what he's essentially doing in 254 is saying 320 applies, and therefore it's 6 years because you can't have 32(1)(c).
Yes.
Because of 320.
Which means if you go back to the issues, which were the agreed issues of 248,
yes.
The first one is to what extent is the claim statute barred by a 6-year limitation?
Yes.
Is that the same as saying, can Prudential use section 32(1)(c)?
It comes to the same thing, yes. Yes, it will come to the same thing, because what he's found is that the section doesn't affect the original claims or the amendments on the 2nd of September 03.
Yes, a purist might say that under section 32(1)(c) you still have a 6-year limitation period, just the starting date is different. But that's not the point that's being
Well,
made.
it's not the point being made. None of this is particularly relevant because ultimately this isn't the right legal analysis anyway, because of what the Court of Justice tells us in December. Because this is all looking at it on the footing that the section is valid, and of course we know ultimately it's not.
Yes, but we do have to, I think, grapple with what the GLO issue was that the judge thought he was deciding, or that the judge was deciding.
Yes.
I think we do need to understand what the issues meant.
Yes.
Yes, for my part at least, were understood as meaning, because
Right.
we touched on the different wording between the two issues, 1 and 2, in paragraph 248.
Yes.
But it's really treated together as, well, if section 320 is valid, then maybe there are some different dates because there are different commencement provisions
Yes.
within section 320.
Yes.
If it's invalid, then
And everything
if
is
you
in
like, all
time.
bets are off.
Well,
But-
my
but
lady,
I'm-
not all bets are off. I'm terribly sorry to interrupt. But not all bets are off. The position, if section 320 is invalid, is that all the claims are in time. That's the burden
Well-
of Learned Friend's submission, that all these points are academic.
Sorry, let me have another go. In terms of what was actually considered
Yes.
by Mr. Justice Henderson, it was essentially the alternative of section 320 being valid or invalid.
Yes, he
He doesn't separately consider or appear to consider issue 1 to the extent that that is different from
I don't accept that. 'Cause
section 320.
I'm going to show you. I'm so sorry. He doesn't separately
Well,
consider it.
That's what I'm struggling with, is at least how was paragraph 1 interpreted, if not an aspect of really coming to the same thing as
So in-
paragraph 2.
So in practical terms, because of the way the revenue put its case, once it lost on section 320, there was no defence left. What that means is that once section 320 is undermined, the claims are in time. And you can see that, for example, in paragraph 255. So this is now looking at the matter on the footing that the section is invalid, first sentence.
Well, if we look at 255, we need to look at it quite closely, I think. First thing that the judge says is, in principle, there's nothing to prevent PHL from relying on section 32(1)(c). And that is still the case. I understand it. It's still the case that it's accepted that the claimants,
Yes.
your clients, can rely on section 32(1)(c).
The question is,
But that doesn't yet answer the question, when does section
what does it do? How does it
32(1)(c),
apply?
when does the cause of action accrue under that section? So that's not answered by that sentence. Then he goes on to say, I don't understand the revenue to argue that PHL could have discovered its mistake before the 14th of July 98.
Yeah.
Well, that can only relate, can't it, to PHL, because that date is selected by reference to the date on which PHL became involved in the proceedings.
No, because the 14th of July 98 date is significant because that's 6 years from the date of issue of PHL's
Yes.
claim. And one has to look at this in the light of the law as it was understood to be in 2013. And the law as it was understood to be in 2013 was not that section 32(1)(c) raised some fact-specific, claimant-specific analysis that might require different claimants to have different dates and to establish it. The law was that the application of 32(1)(c) depended on the true state of affairs being there to be discovered. And so it was the relevant ruling establishing the unlawfulness that provided you with the earliest date, which is why my submission is that making that finding for PHL, it would apply just as much to PAC, and it would apply just as much actually to anybody else in the GLO. And saying that it would apply just as much to PAC, that's exactly what we see in the order. PAC's claims going prior to 6 years are also held to be in time. I haven't got there yet. I'll show you that when I get there.
So can I understand, because you took us to a 2006 date, later as the date of discovery, that's based on a skeleton argument, but here we're looking at a different date.
Well, because here, what Mr. Justice Henderson is dealing with is what he needs to deal with in relation to PHL.
Well,
That's what he's setting out in the judgment.
Why is he only dealing with PHL? You say because once he's decided in relation to PHL, a fortiori same would apply to PAC.
Yes, because they were earlier, and he's already found in 254 actually, even if the section's invalid, the claims are in time. The original claims for PAC are in time. And all of this is in a context where
Where does he in 254 find that Prudential's claims are in time?
Oh, well,
So it's no effect on Prudential's original claim.
But that's section 320 doesn't have any
Yes.
effect.
yes.
But he's not actually. He doesn't actually say that Prudential's claims are in time.
No,
254, does he?
Your Lordship is right. He doesn't say that in terms in 254. Where he does say that is in the order. The reason he doesn't need to deal with it in the judgment is because he's not faced with any argument about PAC being out of time, because he's been told by the revenue that if they're wrong about section, that if they're wrong about 320 being valid, all the points on limitation are academic, and he's only got argument on these two relating back questions.
Do you remind me, Mr. Brenner, what is the date of the ECJ or CJEU decision which said that the UK legislation was contrary to EU law? We've got one was for ACT in December 2006. What was the other one?
Yes, so the one that says
that Herx?
the one. Oh, I'm so sorry.
Was it Herx?
The one that said that ACT on inbound dividends was unlawful was also FII CJU1. Hurst was dealing with ACT and the group income election on an outbound dividend, so that was a different factual situation to this one. Hurst was the 8th of March 2001. But Hurst was not dealing, at least not directly, with the issues with which Prudential and FII are concerned, because it was the dividend was going from the UK overseas.
so going back to my lord's question, is it it's 2006 is the definitive decision on this issue?
On the unlawfulness of the ACT provisions.
No, on
no.
the corporation tax.
Well, it can't be any earlier than that, because but there would have been a question on the law as understood in DMG whether for corporation tax it was actually later, because in the first reference, 12th of December 2006, the revenue, of course, said that they had won on the corporation tax issue, and they persuaded this court in 2010 that they had won on the corporation tax issue. It was the second reference that clarified that the UK credit system, looking at D5, was what was under consideration there, that was unlawful. That was the introduction of the nominal rate credit. That's why I give a slightly more complicated answer than simply saying for corporation tax it's also 12th December 06. There was a finding on the first reference that the ACT system was unlawful by the ECJ 12th December 06. There was still argument to be made after 12th December 06 about what the effect of the decision was for
I think it would
corporation
be
tax.
helpful if perhaps you and Mr. Ewart could agree a note on the basis that the law was, as Deutsche Morgan Grenfell said it was. What were the date or dates of the relevant European rulings which declared the legislation in issue in this GLO to be incompatible with EU law?
Certainly, I'm sure we can seek to do that. want to know is in which of the hard copies I'm sorry,
So we've looked at 255, or is there more to get out of 255?
I think we've looked. I've also managed to lose my place. Would you just give me one moment and look at? I was finding the date of ECJ3.
Well, we don't need it right away.
No. I'm sorry if I hadn't given it to you. It was the 12th of December 2013. Was ECJ3. So we'd looked at 255, and Your Lordship has my submission that reflects the way in which the revenues case was being put before Mr. Justice Henderson. I'd showed you the passage in the transcript in the supplementary bundle, and the point that these issues were academic. If 320 was invalid, then what he does. There's a point about separate companies in 256, which I don't need to take up time with. It's 257 when he deals with the second question, which is about relating back in relation to the ACT claims. They're the ones that have been made in October 2009. And Mr. Justice Henderson says he thinks that question is probably academic, since it seems to me the claimants would probably be able to rely on section 32(1)(c on the ground they couldn't have been aware of the invalidity before read short at the earliest, FICJ1, and then he goes on, in case it matters, and briefly to state his views on the question, and his conclusion is that they can be related back. That is paragraph 259.
And that was the point that Mr. Hewitt sought to raise in this court, and we refused permission.
So the reference
it was to do with ACT.
The reference sought to do two things, both in relation to ACT. The first was to reopen that relating back question, which was the one determined in 259, and the other was to argue for the 8th of March 2001 date as being the relevant date for the ACT claims, and permission was refused on both of those arguments.
It's very odd because 257 is quite clearly drafted by Mr. Justice Henderson on the basis he's not decided when people could have been aware of the invalidity. He's saying it's probably academic and that they'll probably be able to rely on it, but in case it matters, I'm going to go on. So he's not deciding anything as to the date of discoverability in 257.
Well, like he clearly does when we come to the order. I would say that the explanation for why it's put in those terms is that there's no resistance from the revenue on this point. So he's expressing his view about what he thinks the position is.
Yes, but a judge who says, I think the position is probably X, and I haven't heard any argument to the contrary, is not making a decision.
Well, we also will need to look at the order.
Yes, well, that I understand. But in terms of the judgment, well, I've made my point. It seems to me to be written as if I don't have to decide this.
And he doesn't have to decide it because it's being conceded. He doesn't say that, but when you look at the transcript, it's obvious that that's why it is that the judgment ends up framed as it is. Perhaps the best thing is if I show you the order, because of course I get home either on the judgment or on the order under 19(23). So whether or not one can pass the judgment and say, well, is it really a decision? Is it not? What we have is a test claim on the issue of limitation, and what we'll see, particularly when we look at the order, is that claim is held to be in time.
I assume, tell me if this is wrong, that at the end of this mammoth exercise, Mr. Justice Henderson asked the parties to go away and agree an order
Yes,
to give effect to his judgment.
That must be right.
In other words, he didn't draft it himself.
I mean, I wasn't involved at the time in this case, but I would be certain that's what happened. Learned friends nodding. Yeah. There was a case management hearing, I think, in January 14, where
So
there
that's
was
after judgment, is that right? So there was probably a consequentials hearing of some sort.
yes, and there's no I think there is a transcript of that hearing, although we don't have it in the bundle. But it's following that hearing that the order is endorsed. I can't recall whether there was argument about particular aspects of the order. I think there were some issues about permission to appeal, and there were some issues about what should happen next in terms of quantifying the claims. But can I show you the order that was made to give effect to the judgment, which is in the supplementary bundle at tab 6, starting on page 65. And you've got a number of recitals. Recital 1, they're not numbered, I'm afraid, but the first one notes Prudential as the test case for portfolio dividend claims, and that's like the claims made by AXA. Recital 3, at the bottom of 65, that introduces this list of GLO issues, which is in the schedule, and I'll show you that. Mm-hmm. And then recital 4 shows the nature of that hearing in July 13. It's all issues, save only for quantification of the amount of damages and compensation or restitution.
When it says all issues, that doesn't necessarily mean all GLO issues.
No, it doesn't.
It's all the issues in the claimant's claim. So
yes, that's right. But that was why I showed you the order of Mr. Justice Park, which shows you what it was that Prudential was proceeding for. And the GLO issues for which Prudential was proceeding as the test case included EU limitation A and B and third country limitation A and B. And we also had the paragraph in that order that what would be tried were all of the issues in the claims. Now, the list of issues in the schedule is at page 77. And that sets out again at the bottom of 78. It's Roman 8 limitation. They're the two issues that are identified in paragraph 248.
and did they displace the drafting of the GLO issues on limitation in Mr. Justice Park's order?
So Mr. Justice Richards, I think, has found that they did. My submission is that they didn't. What I say this did is it identified what needed to be determined in order for those GLO issues to be answered.
Well, isn't that a rather dangerous submission for you? Because wasn't one of the original GL issues asking when the limitation period started to run? And that hasn't been answered. All that Mr. Justice Henderson said was, these claims are in time. He didn't say, this is when the limitation period started to run.
No, I don't accept that characterisation of it. What is happening here is that the revenue has taken a position in defence of the claims that it's section 320 or nothing. And the consequence in the test case, as I'll show you, is that the test case claims are held to their full extent to be in time. And that has consequences in my submission for what the applicable date is for other members in the GLO.
I mean, the only point I'm making is that if you go to tab 4, page 43, the original GLO issue asked specifically from what date does the, I think it must be applicable, limitation period start to run? And that has not been answered.
My Lord, my submission is that that specific question didn't need to be answered because of the revenue's acceptance that absent section 320, all the claims were in time.
Then I don't understand why you say Mr. Justice Richards was wrong to say the issue superseded the original ones.
Well, it may be that it's a sort of unhelpful semantic debate. I suppose it depends what one means by superseded. I suppose what I'm focusing on is what needed to be decided in order to answer the GLO issues. And whether one says that that overtakes. The way I put it below was that it was a more precise and more specific formulation of what needed to be decided.
What is the answer then to the question posed by that particular GLO issue?
Well, my submission is that the answer, when you look at the revenues concession, is that the date is not earlier than the 12th of December 2006. And if I'm wrong about that...
Well, is that an answer to the question? From what date? Is that an answer to the question?
In my submission, yes. Saying not earlier than a particular date is a perfectly sensible answer to the question. If I can just deal with what is set out and what is decided by this order. So I have shown the court the issue, recapitulating paragraph 248. That's addressed, and the answers given to those issues in Declaration 11, bottom of page 71. And the declaration is that the claims in mistake-based restitution are not subject to the limitation period in section 320 and are in time. And that final part of declaration, and that's critical, because that's why in my submission there is an answer that's, it's not just 320 is invalid, oh what now? There's a finding that's declared that the claims are in time, and that's why I emphasised up front that PAC and PHL, they needed 32(1)(c) in order to go back further than 6 years. And you can see that when that rejection of the revenues limitation defence is carried into the operative part of the order, in particular paragraphs 3 and 5, and you can see paragraph 3 little a towards the top of page 72. All of this is subject to 4, 5 and 6, and nothing will turn on that, as I'll explain. But what is upheld are the claims for restitution of payment by mistake of taxes unlawfully exacted, and upheld 3 little a, claims for payment of tax on D5 income not due because the relevant credit wasn't available. Now that's the equivalent of the AXA IUK claim. I fully accept it says D5 not D1, but the judgment, paragraph 27, tells us that there's no difference between D5 and D1. And then 3D, that upholds the ACT claims, and they're the analogue to the claims brought by GREA. 4 tells you about how the claims are to be calculated. Nothing turns on that for my purposes. And then 5 is important because that identifies the dates. And the claims that are upheld, they're for tax liabilities paid after 1 July 1990. That's for EU resident companies. And then it's 1 January 1994 for EEA, and then for third countries. What that, of course, reflects is the date upon which the freedom of capital became live for those 3 types of companies. So the EU freedoms were engaged from 1 July 90 for EU residents, and then it was later for EEA and for third countries after the standstill ceased. So what you have there is claims being upheld 13 years and 9 years earlier than the issue of the claim form in 1993, long outside the usual 6-year time limit. And I've made the point that the reason for that is because there's been a concession that the earliest start date is the 12th of December 2006, and that's the revenue skeleton in this court, paragraph 90 of the supplementary bundle, page 257.
Can I go back to the issues identified in the schedule to this audit? Because those are the ones identified as the GLO issues. We know issue 2 is simply a question of whether section 320 is valid or not, and nothing now turns on that, because we know now that section 320 is invalid. So none of the claims are barred by section 320. Issue 1 asks, to what extent is the claim statute barred by a 6-year limitation period? And that's not, to what extent is the claim statute barred? It's, when we looked at the judgment, I suggested that, are these claims subject to only a 6-year period, or can the prudential take advantage of section 32(1)(c)? And that's the question.
Yes.
And the answer to that is, the claims, none of the claims are statute barred by a 6-year limitation period, because prudential can take advantage of section 32(1)(c).
Yes.
But it's not asking the question, is it? Under section 32(1)(c), are they in time or not? You see, just as a matter of what is the question, which is identified, is which box do you put it in? Do you put it in a section 2 box, you've only got 6 years, or do you put it in a section 32 box, and you've got a longer period? And the answer is, they all go into section 32 box. But it doesn't answer, it doesn't ask the question. If you're in the section 32 box, are you in time?
Well, my lord,
But that's why because it's clear, and I have no difficulty with this, that the judge is trying the prudential's claims. So he has to decide for the prudential's claims whether they are in time or not, because he has to decide whether to uphold the claims or not, and you've shown us. And I have no difficulty with this. He decides the prudential's claims are in time, and you've explained why he decided that, which was because the revenue conceded that they weren't arguing for any earlier section 32 date. But that's not the question before us. The question before us isn't whether he decided whether the prudential's claims are in time. The question before us is, was that a GLO issue? And at the moment, I'm struggling with, if the GLO issues are just the ones here in this schedule, the ones in paragraph 248, it's not obvious to me, but either of those two issues asks, are the claims in time? They ask, which period is applicable?
well, okay. Clearly, on its face, issue 8 does not say what is the applicable date for section 32(1)(c), because there is no express question of that nature. Of course there isn't. We can all read the document. What I am saying is that in order to determine the extent to which the claim in the test case is barred by a 6-year limitation period, what one is needing to do, of course, is to make a finding as to the date of applicability of section 32(1)(c). That's inherent in the exercise that's being done in the order. There needs to be a conclusion that's been reached about whether that test case can rely on 32(1)(c) or not, because to the extent that it can't, and that might be because the section doesn't apply at all, or it might be because the claim form was issued more than 6 years after the relevant date in section 32(1)(c). If 32(1)(c) doesn't apply, then, as your lordship rightly says, you're back to the ordinary section 2 6-year time limit, and payments that do not, claims in respect of payments which do not benefit from 32(1)(c), those payments would be barred by the 6-year limitation period. So what I'm saying is that it doesn't matter that question of the date is not expressly identified as a GLO issue, because the finding is inherent in the ruling, or the necessary finding, or at least a finding that is sufficient for these two follower cases here. It is inherent in the rulings that have been made. Because for prudential, take PAC by way of example. For the order to have been made in the terms that it was in paragraph 3 and 5, the date of discovery for section 32(1)(c) purposes, that must be within 6 years of the date of issue of the claim form of the 8th of April 2003. Otherwise, there is no explanation for how that order could possibly have been made.
Are you effectively saying that the glow issue for these purposes goes beyond what's expressed in either the original glow order or in the schedule that you've shown us here?
I don't need to go as far as that. What I'm saying is that there is a judgment or order in relation to limitation. So going back to part 19 and 19 spot 23. What I need to show is that there's a judgment or order made in relation to one or more GLO issues, and because it's that judgment or order that's binding. And in relation to, it's obviously broader than on, there certainly is a judgment or order in relation to the GLO issue. And what I'm saying is that it's inherent in that judgment or order that the date cannot be before. And my preference is 12th of December 2006. I don't think I've actually articulated my fallback of
But that's not what the
and
judge decided.
2003.
He didn't decide it was December 2006. He said it was not before 1998.
For corporation tax, that's right.
Yeah.
And then
So suppose a claimant issues a claim form in 2005. How does that help?
but one has to do this in stages. One has to work out what's the effect of the judgment or order. If you are with me that the date is 12th of December 2006, that's fine for the claimant in 2005. If you are not with me and you are saying, well, all that's been decided is that it's not earlier than 1998, then the claimant in 2005, he may have to go and have his argument. If the revenue doesn't accept that he's in time, he may not be entitled to rely on the binding effect of the judgment or order. That doesn't affect AXA IUK. It issued its claim on the very same date as Prudential did.
Yeah.
There's a different conversation that arises potentially for GREA, because of course it's later. And that's why for GREA, I've made the point that either it's 12th December 06, see the revenues concession in this court and Prudential, or alternatively, it's October 2003. And the reason for that is Manila Friends' concession that if 320 is invalid, then the relating back issues are all academic. So what was being accepted by the Revenue and Prudential High Court is that an ACT claim made in October 2009, that there was no issue about 32(1)(c, that 32(1)(c applied. So just looking at those two claimants, as I've said, so for AXA IUK, claim issued at 8th of April 2003, like PAC. And AXA is in the same position as Prudential. And Your Lordship has my submission that in Prudential High Court there's no argument from the Revenue, notwithstanding that it is the test case for the limitation issue. That clearly doesn't change. There is a GLO issue of limitation. However it has ultimately been formulated, there's no argument from the Revenue that a date prior to 8th April 1997 is the relevant date for section 32(1)(c) purposes. And that, as it happens, is consistent with the position that the Revenue took in other litigation, even after DMG was under challenge. And you can see that, for example, in what the Chancellor records of the Revenue submissions made in order to secure permission to appeal in Class 8, and that's in his permission decision in Class 8, Authorities tab 34, and it's paragraph 17. It starts at page 1160, and the passage I need is at 1164. And it's the final six lines of paragraph 17, which record the way in which the Revenue in Class 8 sought to distinguish Prudential and to say that the point was still open to them.
It's para 17.
Yes, so the reason I'm showing you this is in Class 8, when it came to the application for permission to appeal to this court, one of the things the Revenue wanted to add in was that DMG was wrong, and there was argument about the extent to which that was a permissible point for the Revenue to take. And the way in which the Revenue sought to show that it was still open to them in that case to argue that DMG was wrong. And this is looking in Class 8 at claims that were made much later in time. It was said, well, nobody, let alone HMRC, could have suggested that Prudential had good reason to believe a mistake had been made before 1997. So that was even in a world where DMG was under challenge. Now, things, of course, then move on again, and the Revenue is looking to argue in other litigation now for a yet earlier date. But what one sees from that is it underscores that the Revenue's own position in 2013 was that Prudential would have been in time regardless of the approach to limitation. So whether it's a DMG approach of the true state of affairs needs to be there to be discovered, or whether it's some other approach, in 2013, the Revenue was still saying a claim issued in 2003 is in time. And that's consistent with the analysis I'm setting out of what was actually at issue in Prudential at the time of the test case, and what has actually been decided in
22 of the Chancellor's decision. Where he says no legal questions being decided in portfolio dividend CA, that's what we've been calling prudential CA, which prevents HMRC seeking to argue that DMG is wrong. You say that's not right. That has been decided and it binds everybody.
Indeed, and I'm saying that it's not open to the Revenue to take an approach which is inconsistent with the outcome in the test case. That's the other thing that I'm saying.
So you say the Chancellor's wrong in this paragraph?
I do, in 22.
Yeah.
And I also say that on any view, what has been determined in Prudential in the test case is that, first of all, a claim made on 8th of April 2003, that benefits from section 32(1)(c). That's PAC in its corporation tax claim. You could say the same thing about PHL and 14th of July 04. That would give you a date of 14th of July 1998. And that, on any view, must establish that the date isn't earlier than 14th of July 1998. That's good enough. Whether I'm right about 12th of December 2006 or not, that's good enough for AXA IUK, because it issued its claim on 8th of April 03, same date as PAC. And you would end up with a diametrically opposed result in AXA's case in comparison to PAC. And then on GREA, here we're dealing with the ACT claims, and we saw those claims, they were added 19th of October 2009, both for PAC and for PHL. And Your Lordship has my point that there's no contest from the revenue on the application of section 32(1)(c) if 320 is invalid. I've made the point about the concession in this court in Prudential 12th December 2006. But I've also got, even leaving that to one side, the concession made in front of Mr. Justice Henderson that if 320 is not valid, the points are academic. And so what you have in Prudential in the test case is the revenue not arguing for a date of constructive discovery or actual discovery earlier than 19th of October 2003. And so, of course, for GREA, it's issued its claim 20th of July 2009. As it happens, before PAC and PHL have amended to make their ACT claims. And so GREA is in materially the same position as PAC and PHL. And it isn't open to HMRC in my submission to argue for an outcome in GREA's case different to the outcome which it accepted in the Prudential test case. Now, just going back to the point about what the Chancellor said, the Chancellor wasn't dealing with an issue like the one that this court has to deal with, because the Class 8 claimants, they were added to the group register after the date of the judgment or order in Prudential. So that the issue that we're debating isn't something that the Chancellor had to grapple with in Class 8. So that's why I say that in Prudential, there are binding rulings that the D5 claims are in time and that the ACT claims are in time. And that, of course, is on the basis of what the revenue accepted. The judge's judgment gives rise to an inconsistent outcome, as between PAC and PHL in the test case on the one hand, and AXA IUK and GREA on the other. And that, in my submission, first can't be right. And it's also contrary to the judge's own finding in paragraph 73 of his judgment, because that was where, this is in the core bundle at page 105, the judge did find that what Mr. Justice Henderson was doing was precluding any member of the GLO or HMRC, absent an otherwise order, from taking a position in the other claims that was inconsistent with that determination, and that's the determination that he identifies in paragraph 69, being the extent to which PAC and PHL's claims fell foul of a 6-year limitation period, and the conclusion was that the claims were in time in their entirety. But of course, notwithstanding what he found in paragraph 73, what the judge's judgment does is it allows the revenue to go back on its own acceptance in the test case that the PAC and PHL claims were in time. And the revenue is being allowed to argue for an earlier date of constructive discovery for the AXA claimants than for the prudential claimants. And that's on the basis of seeking to argue for dates that would have put the prudential claimants out of time on any basis. And that's why I emphasise the fact that AXA RUK's claim was issued on the very same day as PAC, and I emphasise that the argument that's sought to be run against GREA, it's inconsistent with the revenue's acceptance that the relating back issue was academic if Section 320 was invalid. And that's especially striking in the case of AXA RUK. When it was an applicant for the GLO, it made its claim on the very same day as PAC. It could equally have been a test case, and yet it's being subjected to radically different treatment from Prudential. Now, the way the judge justified that ruling is in his paragraph 78. And it's all tied to whether Mr. Justice Henderson was making a ruling, a determination as to a date for all claimants in the GLO. And I say that that ignores the acceptance on the revenue's part that the claims were in time and the concession of the 12th of December 2006 date. And it misunderstands what Mr. Justice Henderson was doing in his judgment and in his order. In the skeleton, I identify sort of half a dozen errors that we say the judge made. And I should probably just take the court through those so you have my position on them. First of all, there's a point about, was there a formal concession or an express concession? And you can see that entering the judge's thinking at paragraph 48 in his judgment, and then it's repeated at 49, 52, and 68. And I say two things. There certainly was a concession. I'm not entirely sure what calling it a formal concession, what else that imports, but there is certainly an express concession that the earliest date is the 12th of December 06. That's the Prudential Court of Appeal skeleton. And there's the acceptance that the limitation points are academic if Section 320 is invalid. That's a concession as well. So that's the first point. So the judge was just wrong when he said no concession. In my submission, he's also wrong if you're going to label it a formal concession or an express concession. But secondly, it's irrelevant whether or not there was a formal concession by the revenue as to the date. We know Prudential was meant to be the test case on the limitation issue, and we know that the 2013 trial, that was the trial of the action. There was nothing being left over save for quantification. And the revenue didn't argue that either 8th of April 03 or 19th of October 2009 were outside 6 years from the date of discovery, actual or constructed. And I do say that it's not open to the revenue, having failed to run that argument in the test case, now to take an inconsistent position in defence of a follower case. We've got a judgment or order, certainly in relation to a GLO issue. And the court has my point that it's not necessary for that issue to be framed as seeking the identification of a specific date. We just need to have an issue, and we need to have a judgment or order in relation to it. And then we need to look at what the judgment or order does. As it happens, I do say that finding as to the date, it is inherent in the ruling that's been made, and you can't interpret particularly the order in any way other than an acceptance that the date of constructive discovery is within 6 years for AXA RUK and for GREA for the reasons I've explained. Because for PAC and PHL's claims to be held to be in time, there needs to be a conclusion as to the applicability of section 32(1)(c), and that's what we've got when you look at paragraph 3 and paragraph 5 of the order. That's binding, and it doesn't matter that the reason why the litigation has got to that point is because the revenue didn't argue to the contrary. So that, in my submission, is the first error. The second is the judge's analysis of what was actually decided in Prudential High Court. And it's a similar point, first of all, in paragraph 69. And it's a point I've been covering already, but 69, that all had been decided was the extent to which PAC and PHL's claims fell foul of a 6-year limitation period. And then 76, well, there wasn't a date of constructive discovery determined. And it's the same point. Necessarily, there has been a finding that section 32(1)(c) is engaged, and that carries with it a finding, at the very least on a not before basis, as to what the date of constructive discovery was.
So I think you would say about 76, it may be true that Mr. Justice Henderson didn't determine dates for all claimants, but he did determine them for those who brought their claims within 6 years of not earlier than July 98.
Indeed. I mean, Prudential never ceased to be the test case for limitation. And if you go back to the intention underlying this GLO framework, you have a whole host of companies who've all brought these claims. It's all very complicated, and it all has to be dealt with in a sensible way. And the way it's going to be dealt with is having a test case, possibly test cases. The parties are involved in identifying the test cases and in identifying the issues, and the court is also involved. And one of the issues that's going to be dealt with is limitation, and it's agreed, and the court is content with that issue to be determined by reference to Prudential, no one else. And that's the opportunity that the parties had to make their case on that issue. What the revenue are seeking in raising the limitation defence against the AXA claimants is to have another go, notwithstanding that GLO framework. And I say that's not permissible. Thirdly, there are errors in paragraphs 70 and 71 of the judgment. 70, not a lot turns on this, but it's common ground that the submission that's attributed to the claimants in 70 was actually the revenue submission. I think both sides submitted a typing correction to that effect, but no correction was made. Nothing particularly turns on that, but 71 is important and worth emphasising. 71, the judge is right when he says, and it's a point I've made this morning, that Prudential High Court has decided at a time when DMG was the controlling authority. And he's also right that the DMG test isn't a fact-sensitive test, because it's looking to the date of the relevant judicial decision on the particular issue. But the judge doesn't appreciate the significance of that observation, because that date is going to be the same for all litigants in the GLO. And that helps to explain in my submission why it's thought that a determination that PAC and PHL's claims are in time would be binding across the GLO, and why indeed limitation was thought to be suitable for delineation as a GLO issue.
That's sort of linked to a question I put to you earlier. I mean, if the whole case was being run on the basis of DMG, it would have been possible for Mr. Justice Henderson to say, well, the date of discovery for corporation tax claims is that date, because that's when the CJEU ruled, and the date for ACT claims is that date, because that's when the CJE ruled, but that's not what he did.
And I accept that on a reading of the judgment. My point is he didn't need to do that because the point had been considered.
And in fact, you go further and say it doesn't matter whether it was conceded or not, it wasn't argued, and that's enough.
Yes.
Is it the case now that discoverability depends on when you conclude you've got a worthwhile claim? Is that a fact-sensitive or claimant-sensitive question?
It may be. It may be that you have a number of claimants who are in a similar position in terms of their resources.
Some taxpayers may get to the worthwhile claim before others.
Yeah, they might do. I can't point the court to a case where that's been held to happen. In FRI, in front of Mr. Justice Richards, the case was argued on the footing that the various claimants had similar resources available to them, similar interest in finding out, and so it would be the same. It was likely to be the same for all. There was a separate issue about whether the date of discovery could come after particular claimants had actually issued their claims. That's a slightly separate question.
It's quite difficult to say. I issued a claim asserting that something was a mistake, but I couldn't have discovered it.
I'm so sorry. What I was trying to say for other claimants, so claimant A issue, does it automatically mean that claimant B has discovered, and there was a ruling on that by Mr. Justice Richard. I don't think we need to get into that for present purposes. You've got, of course, actual discovery and constructive discovery. You may have actual discovery preceding constructive discovery, at least theoretically, in the case of a particularly astute taxpayer.
The BAT case seemed to be argued almost on the basis of sort of a hypothetical, well-resourced taxpayer, rather than the particular individuals.
That's fair. In terms of BAT, the judgment from Mr. Justice Richards, yes, that's a fair assessment of it. That, of course, is because you're dealing with quite a, homogeneous is quite the right word, but a group of litigants who are in a similar position in terms of their access to resources, access to advice, all of that. None of that in my submission really helps with what was decided in 2013, because what this court has to look at is what was it that was binding in 2013 and then upheld in 2016. So I've done the judge's first 3 errors. The 4th error is the one at paragraph 77, and this actually also picks up on a question my Lord Justice Lewison raised with me earlier about claims brought later in time. And the judge took the view that the effect of my submission was that a claim much later than PAC and PHL, that would have to be in time. And his example was 23rd of October 2013. Now, the answer to this depends on where you get to in terms of what's been determined. I mean, if there had been a determination that the earliest date was 12 December 06, clearly that doesn't help you with a claim brought on 23rd October 2013. It would be different, and I think I'm right in saying this is what this court probably found in FI Court of Appeal in 2016, never mind not earlier than. If the court said the date is 12th of December 2016, and that is the date, no earlier, no later, then the October 13 example would be out of time. But if it was not earlier than, you'd be looking at this judgment and you'd say,
I think your point is that the judge ruled that any case brought within 6 years of July 1998 is in time.
Yeah, and that's as far as I need to go for AXA UK.
If that's what he ruled, you're in time, never mind about other claimants on the register who might or might not be in time on that basis. Would it be open to such a claimant to say, well, it may not be, he's not earlier than 98, July 1998, but I want to argue it's later?
Yes, I would submit that it would be. And whether it can do that or not, as I say, is whether the binding ruling is not earlier than, or simply that is the date, because that claimant may well have a problem if it's that is the date. So that was error 4. Error 5 is a recurring theme in the judge's judgment, particularly paragraph 79, bottom of page 106, that there's a distinction between a common understanding between the revenue and the claimants in Prudential on the one hand and the judgment or order on the other. And my submission is there's nothing in that distinction, and I've made the points. It's either the concession or alternatively it's the analysis of the judgment or order that give us the dates that we need. And I also would say this, that the question of the applicability of Rule 19(23), it can't be avoided by saying, well, particular dates, they reflected a common understanding, because what we have is the judgment or order that's given in relation to the issue of limitation. That's a GLO issue. And we've got rulings that the PAC and PHL claims are in time. And then error 6, that's the analysis of Prudential Court of Appeal at paragraph 82, where I do say that the judge should have placed weight on the concession that was made in this court, and indeed on this court having refused the revenue permission even to argue for an 8th of March 2001 date. Can I just next deal really with headlines to make...
Sorry, can I just go back to one point? You a couple of moments ago, you in answer to a question, you said that the position of other claimants will be affected by whether the decision was that constructed discovery was on a particular date or not earlier than a particular date.
Yes.
You drew a distinction.
Yes.
But is it rather strange that determination of a GLO issue shouldn't be apparent? I mean, that point is of clear significance to later claimants, whether it's on the face of the judgment or order, July 1998,
Yes.
or not earlier.
Yes.
Is the fact that it's not apparent and that might need to be determined at a later date relevant to the point you're arguing?
Okay.
You're saying this has been determined as a GLO issue, but you're then suggesting there's some lack of clarity as to exactly what is determined.
My lady, there's no lack of clarity. If the court said in the test case, we have enough material here to say that the date cannot be earlier than X date, call it the 12th of December 2006, and that's what's relevant to this particular claimant who is the test case. The court might leave open. It may mean that the GLO issue wasn't very satisfactorily framed, but that's a different question. The court might leave open what would happen for claimants who bring their claims more than 6 years after that date. That is a possibility.
Well,
it doesn't mean it's not apparent. It depends what one means by apparent, I suppose. One way of looking at it is you can't see it in the judgment or the order, and I've made my submissions that actually you get this both from the judgment and from the order. If one's saying it's not apparent because the court hasn't reached one single date, I would respect...
I'm not suggesting that. I'm just suggesting if we don't know the answer to the question of whether it's a particular date or not earlier than, that maybe that suggests...
Well, no, my lady, I
start on whether it's been decided.
I'm saying we do know the answer, and there's nothing wrong with an answer put in terms of a not earlier than date. It doesn't mean that what was being adjudicated on wasn't a GLO issue, and it doesn't mean that which has been decided is anything other than binding for what it decides. What we're engaged in is an analysis of what is the content of the judgment and the order. And it would be a very odd result in my submission to have had Prudential designated as the test case for limitation, to go through all these adjourned trials and iterations and finally of the trial in 2013. And then the conclusion is, oh, actually, no, this is just a ruling on PAC and PHL's claims. It doesn't actually tell you anything useful for other claimants. That's a very surprising conclusion in my submission. And yet that seems to be where the judge ends up. And I've made my point that the judge got close to an answer that would actually have enabled
Yeah,
these
you like
claims
his
to...
paragraph 73.
I like his paragraph 73, I certainly do. He was getting close to the right answer, but he didn't draw the right conclusion from it. Just on the revenues responses, I want to get ahead into reply, but this is all there in the skeleton. It may save some time, and I've covered some of these issues already. There are 4 broad headings. First of all, my friend says limitation issues were fact-specific, specific to PAC and PHL, so not suitable for determination as GLO issues. That ignores what was actually designated as a GLO issue. My friend may complain in the light of developments in the law later, fact-specific or the rest of it, none of that applied when those issues were being designated. It also so happens, and this is the point we make in the supplementary skeleton, paragraph 12 of Malone Friend's own statement of case, before Mr. Justice Richards accepted the claimant's assertion that there were GLO issues on limitation. And that was paragraph 20 of AXA's statement of case, little b, page 191 of the core bundle, that the GLO issues included the applicable date for the commencement of the limitation period. That was admitted in the revenues statement of case at paragraph 12, among other paragraphs, core bundle, page 200. That admission's never been withdrawn. Second point is to say, well, even if there were GLO issues, doesn't follow that Mr. Justice Henderson decided the date of discoverability for all claimants. Well, I've done that. The court's got my submissions on that. I say you do get the binding ruling out of the judgment and the order. The third point is there's a suggestion that I need to say, and this is my friend Skeleton, paragraph 29, that I need to say that it's only claimants in materially the same position as the claimants in Prudential that can succeed. That's a misunderstanding of what I'm saying. I do say that the AXA claimants are in materially the same position as Prudential, and indeed I rely on that. But I'm not saying that it's only claimants who issued their claims by the same date as Prudential who can rely on the ruling. It depends on what the analysis is of what has been decided in the test case.
Well, I thought you are saying, are you not, anybody who makes a claim within 6 years of the 14th of July 1998 is in time, and that's what the ruling says. It doesn't matter whether they are materially the same or different or whatever it is. That's what Mr. Justice Henderson decided.
Yeah, that's right. So that's a misunderstanding of what it is that I'm saying. And then fourthly, there's an odd point in paragraph 30 in our friend's skeleton where the revenue tries to flip the position around and say, well, how does this all work if Mr. Justice Henderson had determined that the Prudential claims were out of time? And I just say 2 things. One, it doesn't help with an analysis of what he's actually decided. And we'd be back to the same old point. You'd have to look at what did he decide, and in the light of what he decided, would it be possible for a follower claim to distinguish itself, or not?
Suppose you've got a follower claim. Sorry, I'm going back. It wasn't issued within 6 years of the date in 1998. It was 7 years after it. So
yes.
It's issued in 2005. Would such a follower claim, would it be open to the revenue to say the relevant question in your case is when it was reasonably discoverable in accordance with what the law now is, or would the revenue be stuck with the concession that the test was the DMG case?
I would say they're still stuck with the concession in that footing, because they shouldn't be permitted to be taking an inconsistent position with the one that was advanced in the test code.
So even though Mr. Justice Henderson hadn't actually decided anything about when the date is, other than it's not before 1998.
Because in my submission, part of what's binding would be the approach to how you answer the mistake question.
But, I mean, this is this is causing me difficulties because he hasn't been asked to decide that. He hasn't decided that in any contested sense. It's just an assumption. This is what Mr. Justice Richard said. It's a common assumption that that's how the law works, and that's not surprising because that's what the Supreme Court said that's how the law worked, or the House of Lords. Does that mean all the followers are then stuck with that approach, regardless of when they issue?
Starting point, yes, they would be, because the framework is if you're adversely affected, then you can appeal. 19 spot 23 sub 2. So the way that GLO is supposed to work is you have the test case that produces rulings, outcomes, findings, and then it's channeled through appeal. We shouldn't be encouraging a circumstance where there's going to be iterative litigation. It's a fact of life that the law changes. It so happens it has changed in a rather spectacular way in the course of the development of the FII GLO, and the court may well recall all the arguments about whether it was open to the revenue, whether the points had been conceded in FII, one issue, estoppel, all the rest of it. And the Supreme Court said, no, we're going to let them run the point. We're going to
deal with all that when you come to the question of ordering
otherwise, yeah, which is where I was going next. And that, of course, the judge doesn't need to deal with. It's raised in my friend's respondent's notice. I was going to say a word or two about it now, and I hope that's helpful. And the starting point, as I was already saying in answer to my Lord Justice Nugee, is that the GLO, it's intended to provide a mechanism giving finality and consistency in the determination of the cases on the register, and it is important in that context. When we look at 19 spot 23 sub 2, in particular, is a clear steer that the way in which challenges, judgments or orders which are binding is that you seek permission to appeal the order. Paragraph 3 says it's page 150 in the authorities. I'm sorry. Paragraph 3, which is the paragraph to which sub 2 is subject, is dealing with parties and claims entered on the group register after a judgment or order which is binding and then was given or made. They can apply for an order that the judgment isn't binding. That, of course, isn't what we're dealing with here. What 3 would be dealing with is people who are on the register much later in time. And I do say that an otherwise order, the starting point for the analysis is that an otherwise order can't have been intended to replace or override the ordinary obligation on a party if he wants to challenge a ruling to appeal that ruling. And that's especially striking in this case, given that the revenue did try to appeal the ruling on limitation, and they failed in that appeal because they were refused permission to do so. So that's the first point in terms of the starting point. Second point, which is linked to it, is that when one's construing 19 spot 23, looking at this notion of unless the court orders otherwise, that can't be intended to permit new arguments of law to be advanced which could have been taken in the test case, but which weren't taken. It can't be a way in to having 2 bites at the cherry. Because all that's going to do is undermine the utility of having a test case in the first place. If it is possible to have 2 bites at the cherry, the follower cases are going to want to become test cases. Now, that may not be practically possible, but it's going to be a recipe for iterative litigation. It will undermine having a test case. Third point is when one looks at 19 spot 23, what that contemplates is an order which is either binding or not binding from the time that it's made, subject to appeal. The reason I say that is that, of course, 19 spot 23, it has to work alongside the provisions on appeals, and you can see that through the inclusion of 19 spot 23 sub 2. and in particular the usual time limits for appealing will apply. What the revenue are doing in saying, well, the law's changed, can we have an otherwise order, please, is creating a power that really, the weight of which 19-23(1) can't stand, some sort of freestanding ability to say, well, yes, I know there's an order in the test case that is binding, because to get to this point in the analysis, I need to have an order or judgment that's binding. But nonetheless, years later, the court can say that it's not binding. And that, in my submission, is at odds with the framework that's set by Rule 23, 19-23. Because those rulings, if I'm right about what's been decided, we've had binding rulings since 2013. They were appealed, but the appeals failed. And now what's happening is, first of all, in 2023, in front of Mr. Justice Richards, and now in this court in 2024. So almost a decade later, if you're looking at the hearing below, the revenue wants to come along and say the ruling wasn't binding after all, and that's not consistent with the limited means of challenge identified in 19-23 itself. So I simply say the revenue's had its chance, and it lasts.
What scope is there then for ordering otherwise? When would it be appropriate?
Well, you can see that form of words, unless the court orders otherwise. You find it in various different places in the CPI, like in Part 36, for example. And you can see it's in the nature of a saving provision. The default, plainly, is for the judgment or order to be binding. Now, there is that override. My submission is that it's a power that one would be expecting that if it's to be exercised, it's the court that's actually giving the judgment or order which would otherwise be binding, that is telling the litigants in the GLO the extent to which it is binding. Circumstances in which it might arise could be many and varied. I mean, one reads of the sort of GLOs on a whole different scale to these ones, of tens of thousands of litigants. One might have identified particular issues, and one may, down the track, find that those issues, yes, they are germane to particular groups of claimants, not to others. So you may not want to say, the court may not want to say, it's not a GLO issue. However, what we do want to do is make an order to say that for these categories of people, the judgment or order isn't binding for them. That might be one example. I dare say there might be others.
Can I put a slightly different angle to you? One of the purposes of the GLO regime may be to extend principles of res judicata, issue estoppel, abuse of process beyond the single claim which is being tried as a test claim, so that those who are on the register are in a similar position. And if that is right, it might be said, well, if a single litigant would be given permission to re-argue a point because it's not cause of action estoppel, maybe issue estoppel, but there are special circumstances and it's not abusive, then in relation to a follower, one of the parties may be allowed to re-argue the point. And what I'm thinking of, I was particularly struck by the way the Supreme Court approached it in FII 2. And one of amongst the cases they cited were Arnold and National Westminster Bank and Virgin and Zodiac. Yeah. Now, in Arnold and Westminster Bank, there had been a point of interpretation of a rent review clause decided by an arbitrator, upheld by the High Court, and then permission to appeal was refused, so it could go no further. Exactly the same point subsequently arose on a different rent review between the same parties.
Yes, I do.
And the House of Lords said, well, there are special circumstances here because the law, effectively the law has changed, and it now looks as though the decision that upheld the arbitrator was wrong. You can re-argue the point. And Virgin and Zodiac, there was a patent held to have been infringed, subsequently amended,
Yeah.
So the impugned seating arrangements no longer infringed, and the infringer was allowed to argue on the inquiry into damages that the patentee had suffered no loss because the law had changed. So I wondered whether that might be a reason why the court would otherwise order, whereas you quite rightly said a few minutes ago, the law has changed spectacularly over the course of this mammoth litigation.
Yeah, what I respectfully say in answer to that is that there's no indication in 19-23 that the purpose is tied in that very specific way to those private law doctrines, cause of action, estoppel, res judicata, and the like. What the GLO framework is doing is giving us something slightly different, which is having the follower cases decided by reference to the binding rulings in the test case. And the question that your lordship put to me would raise very starkly, in particular, the point that you would have an order which had been binding, and indeed it would have been binding for 11 years on the footing that we actually would get to this point, because we only get here, if I'm right, that there is a binding order, and that order goes all the way back to 2013. And it would suddenly be becoming unbinding. And as I say, that is at odds with the way in which the GLO is supposed to proceed in terms of having the adverse rulings challenged through the appeal process. I accept, of course, that there are examples, and Arnold, no doubt, is one, Virgin is another, and the Supreme Court goes through some of those, wherein litigation involving the same parties, you have the analysis of cause of action estoppel, then issue estoppel is more discretionary, all of that. That isn't what we're dealing with here, and one does have to grapple with, well, at what point in time can this order actually be made? Thing one, the court has my submission about the timing. And the second point is, well, on what basis should it be made? And it cannot be right in my submission that one has a test case which is identified as such, and the parties have decided to argue out the issue by reference to that test case. And then, because of the fact that the litigation has taken such an inordinately long time, that suddenly that process of having had the test case rulings is then undermined.
Well, I put the point to you partly because in your Sturgeon argument you say, well, the revenue shouldn't be allowed to run a point they could have run before Henderson and Henderson.
Yeah.
Now, if we're into Henderson and Henderson territory, which is the way you put it...
Well, I was drawing an analogy with Henderson and Henderson, yes. Because the difference, the difference between what happened in FII and what's happened in this case is, of course, that the revenue sought to appeal and were refused, and that was the end. And that was the end of the road.
In the prudential, you mean?
In prudential, yes.
Yes. Well, that struck me as being analogous to the rent review case where the claim couldn't go any further because the High Court refused permission to appeal.
Well, but it doesn't have the feature of being the test case in a GLO framework.
No.
And it must be relevant in that context that you've got the AXA claims, which are factually indistinguishable from the claims of PAC and PHL. And I do rely, not of course as authority, because it's on a permission to appeal decision, but on the observation of the Chancellor in Class 8, paragraph 14, that, as he put it, the whole substratum, the whole basis of a GLO is that decisions are intended to bind all the claimants. So I'm so sorry, it's paragraph 14 of Class 8 in the permission to appeal judgment. And that is at 1164. And that's why the analogy in my submission is it's not with Arnold and NatWest. For example, it's because you have a regime where the intention is that the test case is supposed to bind all the claimants, and that needs to carry through. And that, I say, is incompatible with using the otherwise order as a means to permit another opportunity for the point to be argued. So I think that those are the sort of headline answers to the revenues points. They also say, of course, well, there are very significant sums at stake. Well, yes, it's a tax case. There often are. But the fact that large sums were at stake, that was one of the very reasons for having the GLO in the first place. So those are my submissions on preliminary issue A in opening. I mean, it may be that I need to come back to the otherwise point a little bit more in reply, depending on how my friend develops his argument, because that's his respondent's notice. But I hope that sets out why we say the judge erred on what had been decided in Prudential, why there is a binding ruling, and why, if we get there, an otherwise order shouldn't be made. And that takes me to ground 2, my ground 2, dealing with preliminary issue B on set-off. That's addressed in the replacement skeleton, paragraphs 49 to 67.
Now, can I ask a question about that?
Yes.
Is this claim in effect limited to compound interest, or is there some other potential head of relief which you seek under this ground?
I think it's actually limited to simple interest under section 35 capital A is how the claim has been computed.
Right.
There is an alternative claim, which is the statutory remedy under Finance Act 2019, section 85, which, as I understand it, I think is accepted would succeed. The issue is whether GREA, I think that's right. I think so, yeah. The issue is whether GREA is entitled to argue for a remedy that would give it simple interest under section 35 capital A.
So is that thought to give a better result for the
yes, it would.
Than section 85?
Yes, the interest rates are higher.
Well, the interest rate under section 35A is discretion.
Well, but there's provision in the order setting out what the interest rate is, and there's no dispute that if that remedy is available, that's what would apply.
I see. Mr. Justice Henderson ordered compound interest, didn't he?
Yes, he did. He did.
You're not saying that that's been decided.
It makes no difference in practical terms in GREA's case, whether it's compound or simple.
Presumably because the set-off was quite...
It's to do with the period of time over which the claim lies. Yes.
Okay, but when you say it's limited to simple interest, well, hopefully you'll get into this, but the one thing that hasn't been ordered by anyone, including at any stage, is simple interest on this. So, under section 35A.
Yeah. So the way, yes, what I'll be saying after the short adjournment is that what's at issue is, has GREA got a remedy at common law in respect of the utilised ACT?
At common law.
Yeah. That's really the question.
Well, I haven't quite understood the use of the term at common law. Section 35A is a statutory provision.
Yes, I'm so sorry, but for section 35 capital A to apply, one needs to identify what the claim is that gives rise to the ability to exercise the discretion.
Has it got to be debt or damages?
Yes,
have to be, doesn't it?
Yes,
but I thought under the Act, if you pay a debt late but before the claim form's issued, you don't get section 35A interest. So it's really the EU.
And I'm going to address your lordship on what was said in Prudential about that, because what the judge decided was that there was a ruling in Prudential Supreme Court that whatever the remedy might be, it couldn't be a restitutionary claim for time value because such a thing doesn't exist.
Yes.
And the short point I make is that actually when you look at Prudential Supreme Court, what was decided was that the revenue was held to its concession, that a restitutionary claim was available in respect of the time value claim for utilised ACT, which is what the Supreme Court refers to as the Category A claim. The revenue was held to that concession. There was therefore no need for the Supreme Court to make rulings about how one might interpret Section 35 capital A. There's quite a difficult paragraph, which I ended up having to argue about again in FII Supreme Court 3 about what Prudential paragraph 78 actually does. But the